And this is the first amended petition to establish the parent-child relationship.
So the state and Ms. Washick have both filed briefs regarding the affidavit required for non-parent parties. And as it states in our brief, basically the OAG is a state, it's not a non-parent party, and the Office of the Attorney General does not believe that that statute applies to suits filed by the Office of the Attorney General.
My response to your prior questions from our last hearing was that the section 102.0031 does apply in this case. The OAG did ask for conservatorship, possession, and access to be made, which is outside of the OAG statute that's in the Texas Family Code. It permits child support. It doesn't permit possession and access through that code. So the code that's being asked to waive the 102.0031 does not fall in line with the OAG's privilege in that case. So I believe that the OAG would need a supporting affidavit based on 102.0031 and the fact that the bill that was created for it states that it applies to both pending and after that date created cases. So after September 1 of 2025 and the ones that were already pending prior to that.
Ms. Khan?
I mean, I think there's just a difference between a private individual filing a case and the state filing a case. And the way this statute reads, it does say like a party that files or intervenes, and Mr. Johnson has not filed or intervened anything here. So, I mean, I understand that it does apply to the family law cases. I just don't think it applies to cases filed by the Office of the Attorney General.
There is an exception to that when it's not filed through the OAG services. So the OAG services under section 231 are for child support, enforcing that child support. And this was asking for possession and access or conservatorship to be established to establish that child support cause. So without possession and access, you can't have child support in this case. So I think it's required under the 102.0031.
Ms. Khan, under your argument, will this result in people just applying for services to get around a statute?
I mean, possibly. I mean, my other thought is that it's really not that onerous of a standing. Like, it's an extra piece of paper to be applied to the back of a thing. Like, obviously we haven't done it, but I don't know that it would be that much trouble for it to get done. And it feels like something that could be easily fixed. And so I don't know that it's going to be something that's people are going to have a big problem with. I think overall as an agency, getting us to do it is going to be kind of more the issue, is because it will have to get our forms redone, and we'll have to get it fixed agency-wide, basically, depending on how this comes out. But as far as just parent doing it, like, I think they're already trying to get standing too. Grandparents to get standing have to go through some hoops, and this is just like one extra hoop. And as far as the state, we already have our standings done under a different statute. We don't have to prove all of that. And so that's kind of our main argument of why it shouldn't apply to us. I don't know that we will need to. And so I agree that the 4D statute really talks about child support, but it's been pretty well established in Texas that, you know, Texas, kind of alone amongst the states, has the jurisdiction to do custody issues as well, because it's required under our state constitution. And
Ms. Wojak, does Ms. Smith, is this issue contested in this case? Does Ms. Smith want the child back?
Absolutely.
Yes, ma'am.
Back.
Has she filed anything?
Yes, we filed a counter petition.
Ah, okay.
We also asked for it to be transferred into district court when we
Remember that when
became
was
part of the case.
I remember the transfer. I see the
August.
answer. see your answer, and I see the motion to transfer to another county or to another, well, motion to transfer to the court. It's is the answer.
(8/14) it was filed.
The counter petition.
Yes.
I don't see it in the court file. Did you all receive a copy, Ms. Khan?
I can look.
I see the 8/8 reset order and then a motion for withdrawal of attorney on 9/2, but I don't see anything in between those. I do see the answer. Let me pull up sometimes things get filed strangely, so let me just make sure I've paged through everything in case it got attached to the back of one of these. I see the motion to transfer. And I see the answer.
Yeah, I don't have a copy of it.
Okay.
Sure why it's not coming up. We filed it on 8/14 at 2:42.
Well, that's very strange.
But it does, as I just mentioned, it does ask for her to have primary possession.
Okay.
Yeah,
Yes, sir.
can I say something?
You may, sir.
Okay, she say,
No, you can tell him. Just tell him she said she couldn't get the baby back.
yeah, she said she couldn't get the baby back until March.
So we've been hearing that for 3 years.
And we've been hearing that for 3 years, so.
Does anyone have anything else they'd like to say?
Actually, Your Honor, I've been asking for my child back.
We
for
can't
the
do that right now, sorry.
That's okay. Thank you, Ms. Wojak. Do you have anything else you'd like to say, Ms. Wojak or Ms. Khan?
I do.
Okay.
All right, so essentially in this case, it's been on file for over a year. Dad was just enjoined. We provided the information in our counter petition, but there's an issue with finding that in August. And then it was also provided at the August hearing and again at the October hearing. Dad was just requested service in November of this month, and service obviously hasn't been perfected. That's going to take an extended period of time, which means we're going to be on file for at least another 6 months, a year, unknown. My client unilaterally wants this child back. She's, to my knowledge, has been telling me that she's been trying to get this child back, has been denied that access. So she wants to have her daughter back. What mom does not want her daughter back? So we are trying to aid that as much as we can. In addition to the 1020031 deficiency, I believe that this case needs to be justly served and that either it be dismissed and resolved, or we need to go to court and just figure out what's going on.
It's like,
Sure.
Mr. Johnson,
Yeah, can I say something?
you may.
Okay, first of all, when it comes down to this baby, now, when my mother got sick, we tried to send the baby off back to her for like 2 weeks, just to hold the baby for 2 weeks. She couldn't come get the baby. She wound up sending the baby to my older sister.
that end up done.
And when my older sister wound up passing, we wound up getting her back because she tried to send it to my other sister that was in Detroit.
And we've
been taking care of this baby. Everything was fine until we asked for some help for this baby. Other than that, it was no problem with us keeping this baby. As long as we was keeping this baby and taking care of the baby, it was all right. But then we asked for some help because things went down for us. We asked for help. And all of a sudden, you want this baby back. But when we tried to give you the baby back, you never came and got the baby. You wind up sending the baby to my sister's house.
won't call her. Won't
And
come
then-
see her.
Your Honor.
Why you don't even call this baby? I don't care. Listen, I don't care who got my baby. If I love my baby, I don't care what issue I have with that person. I'm still call and talk to my baby. No reason. You don't have no excuse why you don't call and talk to this baby that you want so much.
Oh, you should
We
say
have-
the same about your own
Nope.
child.
Or call it too.
Okay, everybody, right now right now we're talking about some legal issues about whether this case can even proceed. Now, unfortunately, your issues that you're talking about, they are more important than the issues we're talking about, because you're talking about the reality of your child and what's going to happen to her and what's been happening to her, and that all matters way more than anything I decide today. Because whether or not this case proceeds or not, your child has to live somewhere and be loved by someone and cared for. And it's more than just loving, it's supporting, it's being there, it's making sure, it's being there for everything. Children have a lot of needs, and they need a lot of guidance and love to grow.
Yeah.
And so this is a sad situation. Let me just say that. But at this point, this case has been on file for more than a year. We're still missing a necessary party. And these statutes, they're new, they're not interpreted, but I do believe based on this statute and the constitutional amendment and the other statutes that were changed with regard to parents' rights this legislative session, including the new presumptions, that the best interest is kind of out the door when it comes to grandparents. There's new parental presumptions for original suits, as well as for modifications now. The legislature spoke loud and clear about at least its intent, whether it was loud and clear or whether it was clear in the statutes is another debate, and clearly it's not very clear here. But it spoke loudly about parents' rights and presumptions this term. And then the people of Texas spoke loud and clear with the recent election about constitutional rights. So I'm finding there's no affidavit per 102.031, and a necessary party is still missing. So I am dismissing this case.
So
So what happens now?
I'll go talk to you in a minute. If y'all want to go back to a breakout room, I can talk to you for a second.
Asking
Okay.
this question because Lorraine just told us last week that she couldn't get the baby back to March. So I'm trying to figure out if I know that we can refile child support on her, and now since we know the dad's name, we can just file child support on both. But what I'm asking is, with the case dismissed, and with her having driving 18 wheeler from state to state, what happens to a little bit? Or we just go back to the office today and refile today?
Let me stop the recording and let you all go back to a breakout room.
Okay.
Yeah. If you want to go back to the breakout room, I'll talk.
Are you
Go
there?
ahead and move it. Yes.